Today we are going to be talking about what it means for a person to be unfit to stand trial, as well as the process involved. Let's say a person is charged with a crime and their lawyer is making the case that they are unfit to stand trial. Being unfit to stand trial means the accused is unable, because of a mental disorder, to defend against the charges they are facing. There are three things that if a judge believes to be true, they will then order a fitness assessment. The first thing is that the accused is not able to understand that they are in a courtroom, who the people in the courtroom are, and why they are there. The second would be if the accused is not able to understand what they are charged with, what kind of pleas they can enter, what can happen to them if they plead guilty, or what can happen if they don't tell the truth in court. Thirdly, the accused is not able to communicate with their lawyer and tell them, even in basic terms, what they want to do with their case. If the judge believes any of these three conditions to be true during the trial, they can issue a fitness assessment at any point leading up to sentencing. The regular criminal process is put on hold for a maximum of 60 days, or until a judge makes the final verdict regarding the accused being fit to stand trial or not. In stage 1 of the assessment, the judge works to establish grounds that the accused is unfit to stand trial through a series of questions. Based on the answers the judge receives, they can then make an order for a psychiatrist to assess the accused's mental state, if necessary. In stage 2, the psychiatrist will assess the accused's mental state in a courthouse or clinical setting. From there, the psychologist will conduct interviews to come up with an educated opinion on whether they believe the accused is unfit to stand trial. Stage 3. A fitness hearing occurs in court. During this hearing, the judge will listen to stances presented by the Crown, the accused lawyer, the psychiatrist, and the accused. The judge will then make a decision on whether the accused is fit to stand trial or not. If the accused is found not criminally responsible, the judge can issue an absolute discharge, a conditional discharge based on drug tests, or a detention order where they are under the care of a doctor and the Ontario Review Board. Often, individuals with a mental illness are faced with multiple layers of discrimination as a result of their mental illness, which constitutes something called a stigma. There is much stigma towards mental health within our society, and this is even more prominent among mental health patients within the justice system. This becomes a barrier for them when they are trying to rehabilitate and return to the community. Society often assumes that people with mental illness are dangerous and feels safer when these people are kept in high-security facilities. However, it is quite to the contrary, and people with mental illness actually benefit from proper integration into a community, as criminal correctional facilities can aggravate mental health conditions.
Don't forget to subscribe to the Demystifying Medicine channel.